Have you ever seen brands offering big discount sales that seem to go on forever? Or when one supposed sale ends, another starts right after it? Have you ever felt like that should be illegal? Well, it turns out that it is illegal, and it's something that brands big and small are being sued for every single day with big consequences. Take the fashion brand Boohoo, for example. They were sued by customers who alleged that the so called original prices that were being marked down were fake. And in 2023, Boohoo agreed to a settlement worth nearly $200 million. Last year, Hot Topic was sued for the same thing, and they quickly settled the case for $14 million. Same story with Rugs USA. Allegedly fake discounts, sued by consumers, settled the case for $12.5 million. So, what's going on here? Why have hundreds of brands been sued for this? And what makes an advertised discount legitimate versus illegal? In this video, I'm going to help explain the federal and state laws that apply to advertised discounts, show you some screenshots from cases that resulted in multi-million-dollar settlements, and give you some tips to help you stay on the right side of the law. I should quickly mention that I'm a lawyer who focuses on advertising and e-commerce compliance, but I'm not your lawyer. And so what I'm going to share is legal information, but it's not legal advice. If you have questions about your situation, you should contact a lawyer in your jurisdiction. So first, let's clarify what we're talking about. Reference pricing refers to when a brand will show an original price, often with a strike through, and then advertise a lower discount price. This is a powerful marketing tactic because it makes consumers feel like they're getting a deal, especially if they feel like they have a limited time to take advantage of the offer. But if something's always on sale, then it's never really on sale, and that's deceptive. And that's the premise behind the laws that govern former price comparisons. The Federal Trade Commission sets out its reference pricing rules in a document called the Guides Against Deceptive Pricing. The FTC rule says that an advertised former price needs to be the actual bona fide price at which the article was offered for sale to the public on a regular basis for a reasonably substantial period of time. The FTC doesn't specifically define what constitutes a reasonably substantial period of time, which creates some ambiguity. However, the intent is clear. You can't just temporarily raise the price of an item for the purpose of marking it down so that it looks like you're running a sale. States like California get more specific. California has some of the strictest pricing laws in the country, and many major lawsuits have been brought under these regulations. Under California Business and Professions Code, Section 17501, an advertised former price must have been the prevailing market price for that item for the 90 days preceding the advertisement. If it wasn't, then you have to clearly disclose the last date on which the item was sold at the regular price. And California's Consumer Legal Remedies Act prohibits making misleading statements about the existence of, reasons for, or amount of price reductions. Let me give you some examples to help make this more clear. Here's a compliance situation. Let's say a brand is selling its jacket for $500 from January through March. Then, for 1 week in April, it says, was $500, now $400. That's compliant because for the previous 90 days, that item was being sold for $500. Now let me give you a non-compliant scenario. Let's say that brand introduces a new jacket and immediately advertises it as being marked down to $150 from $200. That's not compliant because the item was not advertised for sale for $200 for the previous 90 days. Here's another non-compliant example. Let's say a brand always runs a sale on its gummy supplement. So, for example, on January 1st, it runs a New Year's sale where you can get 25% off the supplement. And when that sale ends, they go right into a Valentine's Day sale that advertises 30% off. And when that one's done, they go right into a spring sale that's back to 25% off, and then an Easter sale, and then a Father's Day sale, and so on. That's not compliant because the original price has not been the prevailing market price for the previous 90 days. So now let's quickly look at some actual cases that resulted in significant settlements. These cases show just how seriously courts take these violations. In 2023, online fashion retailer Boohoo and its subsidiaries agreed to a massive $197 million class action settlement over deceptive pricing practices. The plaintiffs alleged that Boohoo advertised virtually all of its products with inflated, fake, original prices, but they rarely, if ever, actually offered the items for sale at those original prices. Instead, these reference prices were used to create the false impression that consumers were taking advantage of deep discounts. As part of the settlement, Boohoo agreed to add disclosures to product pages explaining that the strike-through prices and the comparison prices and the advertised savings are not meant to represent a former price, but instead reflect Boohoo's own opinion of the value of the products. That can be a compliant way to avoid having former price laws apply if the brand makes it very clear that a strike-through or a comparison is not meant to refer to the former price at which an item was sold. Hot Topic recently settled a class action case brought by California and Oregon consumers who made purchases from Hot Topic's website. Like in Boohoo, the lawsuit alleged that Hot Topic advertised fake discounts for its products online. Consumers sued, and the brand paid out $12.5 million to settle the case. And similarly, Rugs USA agreed to pay $14.2 million to settle a case alleging that they advertised fake discounts for products on their website. That settlement covered consumers who purchased from Rugs USA's website and who reside in California, Washington, Oregon, and Missouri. And again, it was the same situation, allegedly fake discounts, consumers sued, Rugs USA paid a lot of money to settle. And dozens of other cases just like these are being filed every single week. At this point, you might be thinking, well, what's the real harm here? If I spend $40 to buy a shirt that's been advertised as being on sale for $40, haven't I received exactly what I bargained for? Well, that's an argument that many of the defendants in these cases try to make. Here's how I think about it. Let's say I'm in the market for a new sweater, and I know that I don't want to pay more than $100. That's the budget that I've set for myself. That's the ceiling. So when I'm shopping online, if I see a sweater that's $120, I'm not going to consider it because it's over the budget that I've set for myself. But if I see an ad from a brand that's telling me that they have a $400 sweater, but today only it's $140, I might be inclined to go over my budget and spend a little bit more because I think I'm getting to take advantage of a big savings that's only available to me today. And so I'm spending more money than I otherwise would have. And if it turns out that that sale was fake, I've just spent $40 more than I would have if I knew the truth. And if a million other customers make a similar purchase because they're being misled by fake discounts, then the value of the case adds up pretty quickly. You might also be wondering how these cases even get started. What customer is going to be so upset over a $20 or $40 discount that they want to make a federal case about it? Can't they just ask for a refund? Well, a customer is not required to ask for a refund or even send you a demand letter before filing a lawsuit. And trying to moot a class action by offering a named plaintiff a refund is not a strategy that works. All it takes to initiate a class action lawsuit is for one customer who purchased your product to connect with a plaintiff's lawyer who's interested in pursuing the claim. And it's often the lawyers who find the clients and not the other way around. If you've ever been served an ad on Instagram that says something like, have you bought a product from this website and do you live in California? Well, you might be entitled to some amount of money. That is an ad where a lawyer has identified a violation and is now trying to find a client to fit with the claim. So now that we understand the regulations and we've seen some of the consequences for noncompliance, here are some practical tips that can help you stay compliant. First, it's a good idea to keep detailed pricing records. So you want to have logs of the pricing history for your products, the dates on which the products were offered for sale at those different prices, the sales volume for the items at those prices, and ideally screenshots of your website so that you can show what the prices were on a given date. That kind of documentation can be crucial if you ever need to substantiate your former price advertising. Second, understand and comply with the 90-day rule. To comply with California's strict requirements, which is a good idea regardless of where you operate, you want to make sure that those reference prices actually were in effect for the majority of the previous 3 months. A good rule of thumb is to take any given day that you're advertising a sale and ask yourself, were we offering the product for the original price for at least 46 of the last 90 days? If the answer is no, then you may need to adjust how you advertise that sale today. And if you're using an older reference price, clearly disclose the last date when that price was in effect. For example, you could say something like, was $200 until January 1st, 2025, to be transparent. Third, avoid perpetual sales and countdown timers that automatically reset. One big red flag is perpetual sales where items are always available for a discount. To avoid this, establish a regular pricing cycle with defined sale periods and return the products to their original prices in between promotions. And if you are using a countdown timer, make sure that the sale actually ends when the timer reaches 0. Many of the complaints in these cases include screenshots where brands have timers that just immediately reset as soon as they run out of time. Finally, be careful with bundle offers. Some of the more recent cases have targeted brands where they advertise a savings if a customer buys multiple items in a single bundle. Brands often will advertise the savings attributable to the bundle just by using a strike-through price. But they need to make clear that the comparison is between the bundle and the price of buying the items individually. You can achieve that by saying something like bundle and save. But where a brand only uses a strike-through, consumers can argue that they believed the ad was saying that the price of the bundle itself is being discounted. It's a subtle distinction, but that extra clarity can be the difference between a compliant offer and a class action lawsuit. So, as we've seen, deceptive reference pricing can lead to massive legal headaches and settlements in the millions of dollars. The regulations may seem complex, but the underlying principle is simple. Be honest with your customers about your pricing. And remember these 5 key points. Number 1, reference prices must be real prices at which you've actually sold products for a significant amount of time. Number 2, California's 90-day rule is a good standard to follow regardless of where you operate. Number 3, it's a good idea to keep detailed records of your pricing history. Number 4, avoid perpetual sales where items are always being discounted. And number 5, when in doubt, disclose more information rather than less. By following these guidelines, you can use reference pricing as an effective marketing tool in a more compliant way. Thank you for watching. If you found this video helpful at all, if you learned something new, please consider liking and subscribing for more content about advertising and the law.